Pledge of Allegiance case. And then the fourth case that Stewart relied on is the Pentagon Papers case, which Stewart correctly says was a great protection for the press, that the press can't be stopped, enjoined, ordered not to publish information that it has in its hands. In that case, the confidential study of the war in Vietnam that the Pentagon had done. Sure, it was an important protection for the press, as was the Near case back in the 30s, which also involved a newspaper. And those are important protections for the press. But, Lewis points out, once again, the court did not rely on the press clause in Near or in the Pentagon Papers case. And the rationale of the decision, the anti-prior restraint rationale, would protect all of us. And none of us could be enjoined or ordered by government not to, say, put online information that the government didn't want published. We'd all be protected by the rationale, the anti-prior restraint rationale of the Pentagon Papers case. And Lewis recalls that the pamphlet cases, the Jehovah's Witnesses cases, Lovell versus the City of Griffin, protected pamphleteers and so on, not the established press that Stewart was talking about, but the lonely pamphleteer out there is as protected as the New York Times would be. And Lewis points out that the non-newspaper speech of civil rights demonstrators who were required during the civil rights movement to get permits from city officials in order to conduct demonstrations, and those were held unconstitutional as a violation of the First Amendment, had nothing to do with newspapers. Those kind of prior restraints are invalid no matter who the government is trying to restrain. So Lewis concludes, not just history doesn't support Stewart, but the decided cases of the court that Stewart himself relies on do not support his thesis. No case, and this is true, it's true to date, no case says that the organized press has any preferred position. No case relies on the press clause as an exclusive basis for the decision. And we were reminded of that in the Citizens United case, where there was some notion that, well, media corporations were exempted from the prohibition on using their funds for electioneering purposes. And there was some notion that, well, that was required by the First Amendment. But the court emphatically shut that down, saying, we have consistently rejected the proposition that the institutional press has any constitutional privilege beyond that of other speakers. Justice Kennedy, in the Citizens United case goes on to say, with the advent of the internet and the decline of print and broadcast media, moreover, the line between the media and others who wish to comment on political and social issues becomes far more blurred. So it doesn't look as though the court, up till this moment, is buying into Stewart's thesis. And indeed, Stewart himself was somewhat inconsistent, wasn't he? I mean, if he really believed the views expressed in this speech, or of the press speech, how come he wrote that opinion in Pell versus Saxby, saying that the press had no rights superior to those of the general public? How come he joined in the KQED, the jail case, KQED, how come he joined in that, in the expression of the general principles in the majority opinion, including that the press has no superior right to the general public? Those decisions in which he wrote, which he either wrote or in which he joined, seem to be inconsistent with the very thesis that he laid out in the speech. Maybe I'm missing something. Maybe you see something reconcilable there, but certainly they're moving in different directions. And then finally, what about policy? Is it good for our country to give special recognition to the press, a preferred position for the press? Lewis thinks not. Thinks that would be bad policy. If the press is treated as an institution, given structural protection, with special rights, that, under the way our system is supposed to function, calls for some accountability. We don't give powerful institutions, whether it's the president, the Congress, or the courts, we don't give them carte blanche to do whatever they want. They're accountable, either to the voters or to the other branches, for what they do. And if the press is going to claim special protected status, isn't it reasonable for the press to be made accountable by the legal system? And perhaps, as Stewart recognized, treated as public utilities, who have to publish whatever information the community wants to publish, or the government wants to publish. If they claim to be a fiduciary for the general public, that is to act as a trustee for the general public, then they have fiduciary duty. You got to carry all this information, whether you agree with it or not. And he also says that singling out the organized press as a specially protected class of speakers is inconsistent with the idea of common values that we have in a class-free society. We don't have any kind of a caste system or a class system that prefers certain categories of citizens or speakers. And he might have said, he didn't, but you can imagine after Citizens United, the court saying that the idea of singling out the press as a preferred position is inconsistent with the idea that the First Amendment protects speech regardless of the identity of the speaker. Doesn't matter who the speaker is, it's the speech that is protected by our First Amendment. And then finally, Lewis points out what Justice White flagged as a major issue in the Brandsburg case. That is, if the press has some special protection, like protecting confidential sources, who is the press? Who gets to say, I have special First Amendment protection? And it's much harder, as Citizens United points out, now than it was at the time of Stewart's speech to identify who we might call the press Brandsburg pointed out that the lonely pamphleteer, under the theory of the Constitution, is as protected as the publisher of the New York Times. So Stewart left the court in 1981. There were no blogs in 1981. What would Stewart say about blogs or any kind of online publishing that any of us can do? Does that qualify us to be the press and to say, well, we don't have to disclose our sources? Or you would think that KQED versus Houchins would have come out the other way if the press had recognized special protection, that the press would have been able to gain access to jail, to government facilities, to government information, citing the press clause, if they had that special protection. But they don't. And if the protection is broadened to include everybody who wants to publish online any way they want, lonely pamphleteers, bloggers, anybody who posts stuff online, then Stewart's thesis completely loses its point. What's the point of saying, well, the press is got special protection when the press means everybody who publishes? Lewis says that doesn't make any sense at all. So it's a fairly devastating critique that Lewis mounted of the Stewart speech. Nicole. Yeah. Who can restrict anything? Oh, they don't have to publish anything. They can keep secret. They do. And that doesn't violate the Constitution because we learned in Houchin versus KQED, there's no First Amendment right of access to government information. The Constitution is not a Freedom of Information Act. So the government doesn't have to provide information to the press. But they could require the press, if they're going to treat them as a public utility, to carry everything. To carry Tornillo's rebuttal to the Miami Herald. To carry information representative of the community. Next Tuesday we'll consider the Red Lion case, which upheld the fairness doctrine, under which the FCC required broadcasters to cover the issues of the day and to include different points of view on those issues. They were mushing around in the content, requiring journalism to include different views with which the broadcasters disagreed. And that's one way that if the press was going to be treated as a public utility, that the government could regulate the press in ways that has never been attempted other than in the licensed broadcasting point of view. But when the smoke clears after this debate between Stewart and Lewis, what is it we know? Well, neither one of them is a historian, and they didn't do anything in the way of original history. They borrowed from others, and you might say, well, it was fairly superficial, their historical treatment, but in fact, nobody else has found anything different on what the framers must have meant by including those 4 words in the First Amendment. It seems to me that concern for the press was, in fact, a major idea that the framers had, and that they definitely wanted to protect the press against government censorship. And when thinking of the press, yes, they were thinking beyond newspapers to book publishers and pamphlet publishers and so on. And the very fact that 10 state constitutions protected the press, but not speech, is eloquent testimony, I think, that those folks back in the late 18th century really meant to protect the press, however they understood it. James Madison, when the Congress passed the Sedition Act in 1798, went back to Virginia and stirred up opposition to the Sedition Act in the Virginia legislature, and went on the floor to talk about what a terrible idea it was that the Congress had passed the Sedition Act, and how important it was to have a free and independent press, saying to the press alone, checkered as it is with abuses, yeah, they're not perfect, they exaggerate, they overstate, they get things wrong. I didn't say that, I'd said that. To the press alone, checkered as it is with abuses, the world is indebted for all the triumphs which have been gained by reason and humanity over error and oppression. Had the Sedition Act, still Madison, forbidding every publication that might bring government officials into contempt or disrepute, had been uniformly enforced against the press back in revolutionary days, might not the United States have been languishing at this day under the infirmities of a sickly confederation? Might they not possibly be miserable colonies groaning under the foreign yoke? He attributes to the press the power to have overthrown the British oppressors and created an independent nation here. The press had a major role in doing that. And to think that Madison just meant, by including or of the press in the Constitution, that it protects written expression as opposed to oral, it doesn't work. I mean, they really did intend for the press to have some kind of protection. And the question is, what kind of protection, what difference would it make in the real world, whether they had structural protection under the First Amendment? Well, KQED versus Houchins would have been decided differently. Pell versus Saxby would have been decided differently. The court has never, as I've said a couple of times, has never relied on the press clause to decide a case, but neither has it foreclosed that possibility. It has not said that the press clause means nothing, gives the press nothing at all. Brandsburg case would have been decided differently in the real world if the press clause had independent meaning. My own view is that the framers did intend some kind of special recognition or status for the press as being essential to our democracy and a check on government power. And that's why they included the press, in addition to the idea that it was the press that had been targeted for prior restraints and censorship. And speech, the freedom of speech, is, yes, it's essential to self-government, to our democracy, but it's also related to the individual autonomy we have, our ability to express ourselves, to be ourselves, to cultivate our own persona. speech is more related to that, it seems to me, and press is more related to facilitating our democracy, but they don't fall into exclusive categories at all. Maybe including the words press was just cautionary and not meant, sort of aspirational, not meant to confer any real rights, enforceable rights. We still don't know. Of course, the statement in Citizens United, I think, is the nail in the coffin for the current Supreme Court, that they're not about to turn around and say, well, the press, because of the mention of the press in the First Amendment, has any special stature. There have been a couple of cases decided since the Stewart-Lewis debate that resulted in very favorable rulings for the press involved in the case. Citizens United obviously did not directly involve the press, and there was no claim that the press clause had any role in that. But one of the cases, that's Lewis's book, and the cases that were inconsistent with Stewart, and there's the architect of the First Amendment, James Madison. One of the cases was Florida Star, which I put in the reader, which involves the competing values, as all First Amendment cases do, the competing values of, in Florida Star, individual privacy, the protection for a zone of privacy that we all need to have, as against the right to publish information of public concern. And the Florida Star case involved a Florida law that made it a crime to publish in any instrument of mass communication the name of the victim of a sexual offense. And one BJF, Betty Jane Freeman, who knows what her name was, probably Betty Jane something, BJF, was sexually attacked in a public park in Jacksonville, Florida, and robbed of 60 cents and a gold chain. And the perpetrator of the crime was not caught. She, after being raped, called the police, and the police made a report of the crime, which they posted in the press room of the police department. That included her name. And the local weekly newspaper, the Florida Star, sent an intern down to the police department, as it did every week, the weekly publication, and the intern copied down all of the police reports and copied in the BJF case her name. And the editor of the paper didn't catch it. Their policy was not to publish the names of victims of sex offenses. The editor didn't catch it. They published an article describing what had happened to BJF, whereupon she suffered. Her mother had received several threatening phone calls from a man who said that he would rape BJF again. The events caused her, BJF, to change her phone number and her residence, to seek police protection, and to obtain mental health counseling. So she was injured by the Florida Star's publication of the truth. This is not false information. It comes as a surprise to some journalists that you can be punished for publishing the truth. Here's the truth. She sues the newspaper for having violated this Florida law that says that an instrument of mass communication can't publish the name of a sex victim. And the jury, this was a long time ago, the jury awarded her $75,000 in compensatory damages, $25,000 in punitive damages. The newspaper took the case to the Supreme Court and argued in the Supreme Court this broad principle. The press may never be punished, civilly or criminally, for publishing the truth. And the court rejected that as a basis for a decision. Didn't say that was wrong. The court recognized, this opinion by Justice Thurgood Marshall, recognized that in every conflict that it had been presented with between the rights of individual privacy and the rights of the press to publish information, it had ruled in favor of the press, but not on the basis of such a broad principle that publishing the truth can never result in liability. And so instead of using that broad brush shotgun crude tool to resolve the case, the court, relying on a precedent in a different case, Smith versus Daily Mail, decided that the proper analysis is this. If a newspaper lawfully obtains truthful information about a matter of public significance, then state officials may not constitutionally punish publication of the information absent a need to further a state interest of the highest order. So, truthful information lawfully obtained about a matter of public concern, if you publish that, you can't be penalized unless the penalty is needed to serve a state interest of the highest order. The court dropped a footnote referring back to the Pentagon Papers case, pointing out that this formulation, the Smith versus Daily Mail